Peña.
No, Juan Rodríguez.
Don
Ok.
Juan. Ok. Ok, perfecto. Mira, pues, bienvenidos todos a este es el segundo meetup de Global Chamber Puerto Rico. Veo algunas caras nuevas y explico brevemente, pues Global Chamber es una organización mundial para la cual trabajo. Yo estoy en Puerto Rico, estoy en Ponce, Puerto Rico, la organización está en Phoenix, Arizona. Y bueno, básicamente lo que hacemos es conectando a nuestros miembros con todas partes del mundo, empresas que están interesadas en hacer networking, empresas que quieren vender, que quieren hacer partnerships, pues ahí estoy yo desde Ponce, Puerto Rico, conectándolos con el resto del mundo. Entonces decidí el mes pasado comenzar a hacer algunos eventos, estas llamadas con gente de Puerto Rico para generar un poco de atracción y para, bueno, para el beneficio también de las empresas locales. Para hoy vamos a estar discutiendo temas de cumplimientos legales al momento de importar y para eso he invitado a Juan Rodríguez de Julio Rodríguez US Custom Brokers, que nos explique un poquito más de, bueno, primero de lo que se presenten, de lo que ellos hacen y de la importancia de lo que es el tema de cumplimiento legal. Y luego de Juan estaremos transicionando con Jennifer Díaz de Díaz Trade Law en Miami, quien nos estará dando algunos ejemplos más específicos al momento de importar, ¿no? Consecuencias legales y requisitos legales que hay que tener en mente. Entonces veo acá Elisa, bienvenida, veo a alguien de Betina Cosmetics, bienvenida, Yamil, Aileen. La idea también es que mientras estemos en el evento, ustedes levanten la mano si tienen alguna pregunta, si tienen alguna duda. Igualmente, acá María de Julio Rodríguez se nominó para traducir si hace falta. Y bueno, hacen networking en el chat mientras se presenta, mientras Juan y Jennifer hablan, en el chat pongan su información, pongan su LinkedIn y así hacemos networking al mismo tiempo. Entonces, sin más, Juan, gracias y bienvenido a la llamada de hoy. Juan, te dejo a ti el piso para que te presentes y nos hables un poquito más de Julio Rodríguez y de, bueno, la importancia de estos temas legales al momento de importar.
Definitivamente. Pues, primero que nada, buenas tardes a todos. Mi nombre es Juan Rodríguez. Soy Custom Broker para la compañía Julio Rodríguez Custom Broker, la cual fue fundada ya para alrededor del 2007, 2008. Llevamos unos 16 años ya trabajando. El headquarter de nosotros se encuentra en San Juan, Puerto Rico. Y recientemente, hace unos 2 años, abrimos una segunda oficina en Miami, Florida, ¿verdad? Y estamos brindando servicio, además de San Juan, Puerto Rico, en Miami, Florida y algunos puertos bastante congestionados en Estados Unidos. Básicamente, ¿verdad? Estamos aquí para darle información de la importancia, ¿no? De orientarse y buscar advice de profesionales tanto como Jen Díaz y nosotros Custom Broker Import Specialist, ya que muchos importadores a veces compran un producto, ¿verdad? Para ingresarlo a los Estados Unidos o en este caso Puerto Rico, sin primero corroborar qué licencia, ¿verdad? O certificaciones requieren para poder cumplir con esa agencia, ¿verdad? Dependiendo del producto y poder así ingresarlo de manera legal, por supuesto. Quería empezar primero, ¿verdad? Con que el primero se tiene que clasificar de acuerdo a una tarifa arancelaria, un classification code, donde va a determinar la descripción del producto y va a determinar, de acuerdo a esa clasificación, qué tipos de agencia involucran ese producto. En el caso de FDA o la comida, por ejemplo, pues envuelven el FDA, ya tienen que verificar si el suplidor manufacturero eh, está registrado con el FDA como el Registration of Food Facility, ¿verdad? La registración, en el cual le permite a ellos manufacturar, sacar y almacenar comida para poder ser importada en los Estados Unidos. ¿Verdad? Eso es un ejemplo básico, pero aparte de la clasificación del producto, también él tiene que registrarse con aduana, tanto como individuo, si es un individuo necesita seguro social, una dirección válida para poder, ¿verdad? Tener aduana, poder enviarle comunicación y algo de lo que se está importando una vez ellos se registren, ¿no? Importante, una vez se registren con aduana, ¿verdad? Que se sometan todos los documentos adecuados, se clasifique el producto, que entonces comiencen la transmisión al departamento de aduana y a la agencia. Es importante saber que una vez se obtenga el release, la persona tiene 10 días para hacer los pagos de los duties o los taxes a aduana, ya que si no se hacen en ese periodo de tiempo, puede conllevar multas o incluso sanciones o que en el futuro no puedan más importar porque sea que aduana ¿verdad? No le permite, no le permita más hacer más importaciones. Además de eso, ¿no? Hay algunos productos que conllevan cuotas o tienen ciertas restricciones, me explico. Cuota se puede dividir en dos, cuota de tarifa y cuota de absolute quota, ¿cómo te puedo traducir eso? Por cantidades, ¿no? Me explico, hay algunos productos que tienen unas limitaciones en cuanto a cantidades o un periodo de tiempo en el que pueda ingresar al país que pague cierto arancel y una vez se acaba ese arancel, o sea, ese periodo, pues entonces tiene que pagar el tax regular. A ver qué más tenemos por aquí. Sabemos que además de todo esto que te mencioné, debemos cumplir, ¿verdad? Y verificar nuestros productos con las diferentes agencias como la FDA, USDA, el EPA, que es el Environment Protection Agency, el ATF, que es el Bureau of Alcohol, Tobacco, Firearm and Explosive, Fish and Wildlife, importante, el Consumer Produce Safety Commission, que eso es una agencia que aunque no tienes que ¿verdad? Reportar nada, pero ellos se encargan básicamente de que el producto que se esté importando, ¿verdad? Cumpla con cierta, o sea, esté seguro para el consumo. Me explico, hay algunos productos, juguetes de bebé, que ellos solicitan ¿verdad? Y requieren unas certificaciones de que estén libres de plomo o metales, aluminio, etcétera, ya que esos juguetes pues, como ustedes bien saben, los bebés se lo llevan a la boca, los tocan y demás, pues ellos se encargan de que ese producto cumpla y tenga esa certificación de que está libre de plomo y libre de ese tipo de metales. También está la agencia de National Administration, el Department of Transportation, que básicamente son los que se encargan ¿verdad? de regular productos como motores, vehículos que están en la carretera, ¿no? Ese tipo de cosas. Déjame ver qué más tengo por aquí. Más lo que es FDA compliance. También importante.
Can I stop for 2 seconds? Can we guess? And sorry, I'm a gringa, it's in English. How many federal agencies there are? Because Juan mentioned a bunch. Guess how many U.S. federal agencies regulate imports and exports total? Anybody? Guess. In the
45.
chat box or scream it.
7.
40
Ocho.
freaking 7. 47. TSA, FMC, OFAC, BIS, the list goes on and on. So Juan's giving you a great overview, but in anybody's business, I want you to think of this as part of the top 10 tips that we're talking about. It's insanity when you're trying to figure out which agencies actively actually regulate you. You can think about a cosmetic, but it's not just FDA, it's FDA and customs. So Juan, such a great point.
Thank you. Volviendo de nuevo, ¿verdad? Es una partecita bien importante que no le expliqué. Antes de que el embarque, ¿verdad? El producto que vaya a importar hacia los Estados Unidos, antes de que se embarque hacia Estados Unidos o Puerto Rico, 24 horas antes, hay que hacer una transmisión previa, que es lo que le llaman Importer Security Filing, el ISF, en el cual se debe transmitir, ¿no? Con el producto o el arancel, el Classification Code, y quién es el comprador, el suplidor, y hacia dónde, ¿verdad?, se dirige, o el último consignatario, en este caso ¿verdad?, el comprador o el último consignee. Es importante que lo hagan, ya que estoy viendo que muchas personas que no están enviando la documentación a tiempo, por lo tanto no se está haciendo 24 horas antes, y esto conlleva una multa de hasta $10,000 por embarques. Muchos ahora mismo no lo están enforzando, pero con la no lo están enforzando, ¿verdad? Como quien dice, le están dando ese break, porque veo muchos casos que envían los documentos tarde, se hace el ISF tarde y no le dan la multa, pero en cualquier momento le puede llegar la multa y son $5,000 por cada embarque. Eso es importante, se me pasó a decirles desde el inicio. Ya luego de eso, pues, podemos seguir con la transmisión de aduana y demás, lo que le había explicado anteriormente. No sé si Jennifer quiere, do you want to explain more about the FDA compliance? Because
Absolutely. I've got a whole lot of slides for you.
thank you.
And whenever you're ready, I'm good to go.
I'm
All right.
ready.
Cool. I will do a share screen if I can. It looks like, give me a second and I'll share here. And you should be able to see my screen, right? I hope.
Yes.
Okay, great. So a lot of by the way, one more time, I'm Jen Diaz. I'm a board certified international attorney and owner of Diaz Trade Law. And sorry, my Spanish is not as good as Juan's ever. It's never going to be. So I'm bothering you in English today. And we're going to talk about a whole lot of things, including FDA. And FDA is one of those fun 47 federal regulatory agencies that regulates imports and exports and what not to do when importing. So many real life stories that I'm sure Juan and I can share with you. So I'm curious, for those of you that are with us today, if you can type in the chat box, which one are you? Are you an importer? Do you import into Puerto Rico or the United States? Are you a customs broker, Juan? We know you are. Are you in regulatory affairs? Are you just interested in FDA? Are you a consultant? Do you do manufacturing, product development? What's your role? I'm curious to hear from all of you. I saw a couple of cosmetic companies in the room as well, which is always great to see, but curious to hear from all of you. If you can, in the chat box, import specialists, a customs broker firm, awesome. So when it comes to importing into the US, we have to deal with FDA, and FDA cares about imports and exports, not just imports all the time, which is what's interesting. FDA has a lot of powers. They have the power over goods in a foreign trade zone or in a bonded warehouse. If FDA really wanted to grab at those, they actually could. A lot of people don't realize that. So FDA has very specific laws, and the laws for FDA are all about health and safety, making sure people don't get sick when they utilize a product. Versus US Customs is all about protecting the border and making sure that bad products don't come into the United States, and or drugs and or weapons and or migrants and or the list goes on. So DHS, Department of Homeland Security, Customs is the unified border agency under DHS. So Customs has two roles: to facilitate legitimate trade and also to protect the border, which is a whole nother story that we can talk about for 1,000 years. But when it comes to importing into the United States, a lot of specific tips. I don't know about you, Juan, but it's very rare where I see a compliant commercial invoice. We're going to talk about a lot of things that people do wrong. One thing that people do wrong quite a bit is they don't realize what's in the US customs regulations and what should be on a commercial invoice. Most people don't put the port of entry that the goods should be going into. They don't put their Incoterms. They don't put their classification. They don't put currency, for example, in the actual currency in US dollars. They don't sign the commercial invoice and date it. There's a lot of these fields that should be on every commercial invoice. So we give you a sample so you can see that to see what really should be on them. Some questions in the mix to put in the chat box for you. How long does customs require importers and exporters to keep records? Is it 1 year, 3 years, 5 years, 7 years? What do you think? 1, 3, 5, 7? Take a guess.
7.
How many years do you have to keep
7.
records?
7.
It's actually 5 years for US Customs. So Customs has a 5-year statute of limitations, meaning you have 5 years to keep records per Customs statute of limitations, meaning Customs can come back after you for 5 years after your date of entry. A little different than IRS, for example. I recommend you keep records for about 6 years because then you're covered for your 5 and life is pretty good. So part of my top 10 tips is who regulates you? You have 47 agencies to pick from, and that could be a lot. So lots of changes are coming up. For example, in the cosmetics industry, we have huge changes that are coming up called MOCRA. And this is a big deal for those of you in the cosmetic industry that are on the phone today. When it comes to the cosmetic industry, on August, FDA just issued a draft guidance to assist cosmetic companies because what's changing this year are modernized cosmetic regulations to strengthen and give the FDA more power over cosmetic companies. There's a mandatory registration for cosmetic facilities, a mandatory listing for each cosmetic product, a mandatory adverse event reporting. It used to be where FDA regulated products that made people sick. And because there weren't a lot of complaints about cosmetic entities or cosmetic ingredients, there wasn't a lot of regulation behind it. There's been a lot of lobbying from cosmetic associations to put more regulations in place and more requirements in place for cosmetic companies. So by the end of this year, everyone who's involved in a cosmetic company will have to register with the US FDA. If you're outside of the US, you'll have to enlist a US agent to represent you, and you'll have to list your product and have good manufacturing practices in place and some allergen labeling as well. So there's a great draft guidance that just came out from the FDA with some sample registration forms. The registration portal is not active yet. Everybody is anxiously awaiting for it to be active, but we have draft guidance that shows what type of information FDA will want from you. Now, every product is vastly different. Cosmetics are different than food. For food products, some of the #1 reasons that FDA would have a problem with food facilities, as Juan said, you don't have a registration with the FDA. Your labeling isn't compliant. So a label in Spanish alone isn't okay. It has to be in English and Spanish. It can't have incorrect or missing statements of identity. It can't miss allergens because I, for example, have an allergen to wheat. It would really bother me if wheat wasn't on the label. It has to say contains what type of nut, contains wheat. Allergens are huge. One of my famous stories is we had a client that imported a little motorcycle, and inside the motorcycle there was candy, and the motorcycle was a toy intended for a child. Based upon what Juan told you for federal agencies, how many agencies do you think regulated the toy motorcycle? Take a guess. Does anybody think which agencies you can think of based upon what Juan's telling you?
I don't have idea.
So exactly, Pucci's on it. So the Consumer Product Safety Commission, CPSC, is one of the agencies, and they care about the motorcycle because it's for children. So this motorcycle was my client's first importation. So imagine they were with me for 2 years and were scared they were going to go to jail for this importation, and I'll tell you why. The handlebars broke off and could have caused a choking hazard for a kid. So imagine you giving this cute little toy to your 5-year-old who then puts it in his mouth and the handlebar breaks off and they choke on it. That would scare you. It's horrible. Then you have Food and Drug Administration that cares about the candy. And just like this says, what does FDA care about? They care about colors. And you can't have unsafe food additives or unsafe color additives added to your particular food. In this instance, our client didn't know better. They didn't have a correct label. They didn't have correct listing of color additives. They didn't get their color additives from a correct source. So Consumer Product Safety Commission is yelling at him because he could kill a child and have one choke. FDA is yelling at him because the food's not safe to consume because the color doesn't come from an approved source. And US Customs is separately yelling at him because he decided to put a trademark on his product that didn't belong to him. He decided to put a logo on the motorcycle because he thought it was cool. He had 3 federal agencies yelling at him for 3 different reasons. So the goods are seized, and there's also a penalty issued after the fact because if you violate someone else's trademark and that person has spent the time to record their brand with US Customs, Customs protects their brand and has the ability to issue a penalty against you in addition to telling the rights holder. So imagine if Global Chamber is registered with the US Patent and Trademark Office, and then Global Chamber also went to US Customs saying, I have my trademark, Global Chamber. US Customs, I want you to protect me. Well, if I then try to use the Global Chamber trademark on a t-shirt and import it, Customs will ask Cesar, hey, do you know this Jennifer person? And Cesar will say, hell no, I have no idea who she is. She does not have my permission. And Customs will seize my products and they'll tell Cesar, by the way, it was Jennifer who tried to import. Let me tell you who she got the products from. And they'll tell Cesar who the manufacturer was, who the importer was, so he could go after us privately. Imagine all of this. And then Customs can also issue me a penalty on top of that. So many different ways that you can get in trouble with these federal agencies and so many different things you should be doing in advance. So one, having a great customs broker like Juan that knows the federal agencies and knows the rules is 100% the way to go for the beginning, but you also need to know the rules of the road and what applies to your particular product. Did you want to say something, Juan? Did I miss it?
Yo te estaba llamando porque
it's just not on mute. Okay. All right. So when it comes to importing food, you also need a U.S. agent. Just like for cosmetic facilities, if you're outside of the U.S., you have to have a U.S. agent. So for example, at Diaz Trade Consulting, my consulting arm, we provide U.S. agent services. So if anybody needs to register a food facility and needs a U.S. agent, that's something we can do in 48 hours. It's a very quick process. You go online, you can create an account on diaztradeconsulting.com, you get your portal up and running, we get a notification immediately, we sign up with FDA, become your U.S. agent, and then we issue a certificate proving that you really do have a registration and we are your valid U.S. agent for 1 year. We do 1 year at a time. FDA requires that you re-evaluate your registration and update it every 2 years. We make our clients update it every year so that we're always ahead and we always know where our clients are. When it comes to being a U.S. agent and importing a food product, period, you have to register facilities with the FDA. You have to provide advance notice to the FDA of what food is coming into the U.S., comply with good manufacturing practices. How many people want to eat food from a company that doesn't have their employees wash their hands or that doesn't clean their machinery? Nobody wants that. That would be disgusting. You would want to have a facility that makes clean food and everybody is healthy and happy. The Food Safety Modernization Act is one of the biggest changes that happened within the FDA pretty much ever, as far as food goes. The idea is it's on the importer of record to prove that the food they are purchasing from the manufacturer is safe. What FDA has said is I'm tired of hearing about pregnant women, elderly people, children having foodborne illness-related deaths in the United States. It's very sad and it's preventable. So instead of having these monstrous issues, I want you to choose who you purchase food from very wisely. I want you, before you purchase the food, to ask a whole lot of questions and develop written compliance plans. And if you're not willing to do that, then you don't have the right to import food anymore. This is what the FDA has said. They've changed the responsibility for importers of food. So we're seeing a lot of food-related inspections of facilities, but not just for the actual facility, also for the written compliance plan that the FSVP, the Foreign Supplier Verification Plan, that's required from the importer. So the idea is if you want to import, you're supposed to tell Juan, for example, here's my manufacturer's registration number, and also this is the company that's going to act as the FSVP importer. This is the U.S. entity that's responsible to verify that the manufacturer is making compliant foods. Foods that comply with good manufacturing practices and foods that are going to be safe, that people can consume without an issue. It's a big deal. It's a lot of responsibility. So if we've seen a lot of FDA inspections for FSVP plans where people don't have them, where people aren't doing it and they're not taking it seriously. So FDA has a lot of ramifications that they can give companies. For example, a lot of errors that companies have. They don't have manufacturers registered. They have wrong quantities. They're not using the right product codes. They're not giving Juan the right registration numbers. It's important to have open communication with the customs broker to provide the broker with the right numbers and the right compliance history. Juan isn't a mind reader. If you have a registration from your manufacturer, you have to provide that certificate or that number to Juan. And Juan will ask for it, but it's better if you provide it. You know that it has to exist because Juan, the end of the day, he's not an external compliance department. He may have a division that helps, but in reality, between me and Juan and everyone else, he should really be charging for this service because that's separate and apart from the import portion, meaning Juan's team files import paperwork with U.S. Customs and FDA to advise Customs and FDA of what goods are coming into the country so Customs can determine what they want to inspect or not. But all of the requirements that I'm talking about, meaning having a compliant ingredient and color and the right labeling, the right nutrition facts column and such, these are all items that Juan really shouldn't be assisting with. That's not part of his filing the customs entry. This is a compliance portion. So things that we do, we register entities, we help companies comply with the right FDA labeling laws, we help companies determine if they're subject to the foreign supplier verification, and we help companies provide due diligence. What's great is the FDA has an amazing dashboard that'll tell you all about your supplier. You'll know if your supplier has ever been in trouble with the FDA before by using the dashboard. Other agencies like USDA, they also have the National Organic Program. You see that seal, the USDA Organic Seal? How many people actually buy food because they're really excited about that seal? And they think that that seal means their product is healthy and that they should pay more for it and it's worth a premium. Well, some companies are horrible and they use the seal without going through an inspection. FDA isn't the agency responsible for that seal. That's USDA, another one of our 47 agencies. There's a special requirement where certifiers have to go to the facility and judge it and determine whether or not it qualifies for use of that seal. If you don't have an active certification in place, you can't use the seal. And if you do, USDA can charge a penalty of $40,000 plus for the use of an improper seal. Really interesting, and we wind up mitigating and trying to negotiate with USDA in regards to those seals. Another big thing is Incoterms that we talk about a lot, which is the Somali pirates ate your ship or took over the ship or the ship crashed in the middle of the ocean or a truck burnt or didn't make it to your facility. Who's responsible? Who should have provided the insurance? Who should have been responsible for the risk of loss of the goods? This is the Incoterms. So we've got a great article on that with a great cheat sheet that I highly encourage any newer importers to review so you know what your Incoterm is, when your risk of loss shifts, and what it should be. The same thing when it comes to forced labor. There's so many new requirements with US Customs and FDA and USDA and all these federal agencies. It's hard to keep up with all of them. but I highly recommend that everyone download the Sweat and Toil app. Sweat and Toil, T-O-I-L, on your phone. It's a free app from the Department of Labor, and it'll showcase the products and the countries that could potentially have a forced labor risk. So it's called Sweat and Toil. I'll put it in the chat box, and it's a free app again. So a lot of people say, what do you mean? Mexico doesn't have forced labor. There are 15 items, for example, in Mexico that are made with the likely use of forced labor. A lot of things you don't necessarily think about. Let's quiz you and see if you guys were paying attention, because I know I'm going fast and there's a lot of fun stuff to cover here. Will customs protect your trademark, your intellectual property, if you record your trademark with customs? Does customs have such a program where you could record a trademark with customs and customs will protect your intellectual property rights at the border? There are 328 ports of entry. It's kind of crazy. And customs does. Good job. Pucci and Eileen, great job. It is correct. So this is the program I was talking to you about where customs can protect your intellectual property rights. What's great is you could search customs database to see who protected their rights. Does anybody here have manufacturing or sales going on in China? Because if so, you may also want to protect your intellectual property in China. We wrote an article with our Chinese partner law firm on how you can protect intellectual property in China versus the US and what the differences between the systems are. It's kind of crazy to note, but if you get there first in China, you could win. Like I could say, I want Nike in China. And if I beat Nike to it, Nike's mine, not Nike. Kind of crazy. But China is a first to register, where the United States is a first to use country. Very different.
So one quick question about that, because I know that intellectual property, if we register it here in the United States, it does not protect it overseas. Is that correct? Unless you take actions for
You
that.
have to register in each country separately. So in the US, we have the Madrid Protocol, and we have a lot of separate countries that you can easily register with as a result of it. But every country is separate. Each country is its own beast, and you've got to register separately. So if there are specific countries that you're selling into, the recommendation is to communicate with our trademark team, and they'll be able to tell you what you should or shouldn't be doing to protect your brand in each country. Because imagine you're not protecting your brand in China, but you're making the product out of China, and China steals your brand, and they register it first. Nothing you could do after that. It's theirs now. Now you can't use your own brand in China. It's a little crazy, but things you really have to think about per country on a country by country basis for each country you want to sell into. When it comes to US customs, a large requirement that I would say this is the #1 beef I have when it comes to importers and customs brokers and where that line is. I see a lot of importers that say, I love my broker. Juan's going to take care of everything. I don't have to worry about anything. Juan's got my back. He loves me. He's got it all covered. And that's great. But Juan makes you sign a power of attorney that's subject to terms and conditions. If Juan gets anything wrong, his liability is $500 a shipment. Whose real legal responsibility is it for US customs purposes? It's the importers. So an importer of record is responsible to use reasonable care when they're importing. And importers, I think, if I was to give every importer a test as to whether or not they're really using reasonable care or even understand what reasonable care means, I think 90% of importers would fail this test. And I think most don't know what their legal responsibilities are to US Customs. This is the reasonable care checklist, and we've got a great article on it, but I just want to be sure this concept is clear before I talk about this again. Is the customs broker responsible to use the standard of reasonable care? True or false? I want to be sure this is heard and understood, and I'm going to reiterate it 5 more times. Is the customs broker responsible to use the standard of reasonable care? True or false? What do you guys think? Good. It is the importer of record that is responsible to use reasonable care. The broker is responsible to use reasonable supervision and control. So the broker has a standard to supervise and control the entry, but the legal responsibility as far as customs is concerned is with the importer of record. We do see that brokers can receive penalties, for example, for saying that an entry wasn't subject to anti-dumping. We'll talk about what that is in a minute. This is a great article that has great questions for every importer that I beg of you to make sure if you ever meet an importer, this is the most important article. We deal with a lot of horror stories where importers don't understand their liability and responsibility. And by the time they get to us, they owe customs so much money, they are likely to go out of business because they didn't prepare and they don't have the right answers as to whether or not their goods are meeting a specific scope of an anti-dumping duty order or not, for example. A lot of companies, unfortunately, are unprepared to import and don't understand what they should be doing. Let's talk about that a little bit more. First, all right, so this is just reiterating. An importer has to have a process in place to use reasonable care in ascertaining their classification, value, and country of origin. What do you think? True or false? Great.
Sure.
Yep,
Yeah.
the answer is true. So when it comes to your classification, this is what Juan started talking about. So Juan has awesome experts when it comes to classification, but there's another really amazing program that Customs has in place that's called the Binding Ruling Program. How much do you think Customs charges for a binding ruling? Anybody? Type
Not
in the
sure.
chat box. What do you think? What do you think Customs charges for a binding ruling?
I don't know. Let's say $1,000. Not
For
sure.
once in our life, it is free, baby. So they
Free?
charge $0 for a binding ruling. Now, I always say be careful what you wish for because it is binding, meaning you have to ensure that you're asking the right way. When I say we submit a binding ruling request, we do a few things that I highly recommend. One is we negotiate and argue and we lobby. We say, I believe the right classification is so-and-so. I believe these are the relevant rulings. Customs, if you disagree with me, you have to talk to me first. There's a regulation that we cite to. Because if our clients don't get the ruling that they want, maybe they don't want it to be published. And if you don't put that regulation in, Customs is going to publish the ruling without your client really being happy about it. So you should always argue for the HTS, for example, that you want before you're sending the binding ruling. Classifications in the US are 10 digits. The first 2 digits are the chapter, then the heading. So for example, tea, and then green tea, and then flavored green tea, for example, and it gets into the actual HTS and the percentage. If you notice under general, it says 6.4 and there's a little 1 with a little squiggly. That means that there's a China tariff associated with this and likely another 25%, which is a lot. But then you see special, which says free and then a whole bunch of letters. These are all of our free trade agreement countries. And then you see column 2, it says 20%. These are countries we hate, unfortunately. These are our bad guy countries. We don't have favored relationships with these countries. This is Cuba. This is Russia. All right, the first 2 digits, let's see if anybody remembers, is the chapter of your classification. True or false? What do you think? The first 2 digits of your classification is the chapter? True. Good job. Yep, we've got our chapter and then our heading, our subheading and such. Perfect. So customs rulings are a great program. We've got a great Bloomberg article just on classification basics. This also goes over the WCO updates, the World Customs Organization updates. Your classification could change 20 times in 1 year, which is insane, but classifications do get updated consistently. Last year, there were over 27 updates to the HTS. It was a lot. So when it comes to binding rulings, this is more on the process itself. Valuation is a fun, hot topic that many have issues with because it's complicated. For example, if you're importing on a DDP Incoterm, that means your supplier likely is the importer of record and there should be a deduction for freight. So we've seen instances where our customer, Our client says, oh, I'm importing DDP. And I say, so why are you the importer of record and not the supplier? I don't know. Well, that's a red flag. And then I see instances where freight is included in the valuation and you're paying customs duties on freight. That stinks. That can be very expensive. These are all things that you work out during the beginning of the import process and your commercial invoice. We want to make sure everything is clearly outlined on your commercial invoice. That's why it's on our cheat sheet. Normally, your value is the price you actually pay for the goods when you're buying merchandise and you're intending to bring it into the United States. Normally, it can be a very easy subject, but it gets complicated if you're using a brother. If Cesar was my brother and he's making the goods in Canada and I'm buying them from him, is he giving me a better rate because I'm his sister than he would give Dana if she was not his sister? Would he sell the goods to me for $5 and to Dana for $50? And then she has to pay higher duties. That would be really mean of Cesar. You wouldn't do such a thing, right? You would charge everybody the same price and you would be fair, regardless of us being related or not. These are things that customs takes into consideration because customs is the second largest revenue producing agency in the United States. Customs collects almost trillions of dollars every year in customs duties. It's insane. So they're right behind the IRS in terms of money, 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 honey. All right, the most common valuation in the United States is the transaction value, the price actually paid to your supplier. True or false?
True.
Good job, true. Country of origin is the next topic. How many people, when you buy something, want to know where it was made? If you're going to buy and use something, don't you want to know who made it and where they made it? Every U.S. purchaser has the right to know that. So anything you purchase should always have a country of origin on it. Now, what's interesting and what a lot of people don't know is the made in the USA claim. Is it enforced by yet another agency we didn't talk about today, the Federal Trade Commission and not U.S. Customs? What do you guys think? True or false?
True.
True. Another agency, because we didn't have enough, right? This is welcome to all 47 of these. So the Federal Trade Commission has their own standards. So we've got a great article. Is made in the USA really made in the USA? Because quite often, people are actually getting penalized by the Federal Trade Commission for stating that a good was made in the USA. But if it's not all or substantially all made in the USA, you can't use the claim. And a lot of companies wrongfully use that claim. I wish more companies had a formal written compliance program in place. And I'm not talking about 500 pages. I see a lot of companies that are mom and pops and they're very small. But what's your process to classify your goods? What's your process to ensure you have a marking on your goods, the country of origin marking? How do you ensure you're using the right value and you don't have improper deductions or additions to the value and such? And how do you know you're using the right free trade agreement? And do you have the right records? We see a lot of companies trying to use, for example, CAFTA or USMCA. What's great is Customs has given us really great certificates of origin. These are newer. They came up with these in 2022 and updated them, where you click on the top. You see where it says click to reset really small. You can pick the free trade agreement, and then it'll give you the preference criterion and start filling it out for you, which is really quite cool. So then you fill out the rest of it and you can use a compliant certificate of origin. We have free trade agreements in place with 20 countries. This is a listing of all of those countries. It's a lot of really great countries. Got a side-by-side comparison chart of all the free trade agreements and how to utilize them. But quite often what we see is if you want to take advantage of a free trade agreement, Customs has the right to audit you, to check, to be sure that you really did so properly. And quite a bit of companies think that they're using a free trade agreement properly, or what we see is, oh, I exported the goods from the Dominican Republic. I can use CAFTA. All it takes is that the goods are exported from that country. That's not good enough at all. Every single free trade agreement has special requirements to comply with, and just getting a certificate of origin alone, that's not good enough. We have to look at the terms of each free trade agreement. For example, for apparel, in some instances, it matters where the yarn is from, where the thread is from, where the apparel was cut or sewn. Every free trade agreement is different. We have to look at it separately. All right, let's see if you were paying attention. True or false? U.S. has free trade agreements in place with 20 countries. What do you think?
True.
Yeah, true. Good job.
Question though, Regen.
Yeah.
Can they say made in America if the parts were put together in different countries and then
What do you
they brought
think?
it here?
All or substantially all made in the USA. That's the standard. All or substantially all. So if you have parts from different countries that are not from the US, what do you think? Assembled in the US from foreign parts. You have to use what are called modified claims like that.
I see. Okay.
Last
Thank you.
few or customs has notices like this. If you ever get notices like this, and I'm going to beg of you, Juan, and I don't know what you guys do in your brokerage, but I work with a lot of brokers that respond to these notices routinely, and they don't necessarily realize how serious they can be. When customs is sending a request for information, it's because customs already knows that they're not happy with you, and they're trying to get you to confirm how not happy they are with you. It can be the start of an actual audit against you. It could be the start of an EPA proceeding. It could be the start of a nightmare. It could be the start of penalty proceedings. It could be the start of all sorts. Normally, when customs asks you questions in the request for information, you're very tempted to just give the answers. I hate that, and I'll tell you why. Because customs is always trying to use what you're saying against you. So instead, my approach is not just customs. I see that you're asking me for samples. That means I believe you're looking into the classification of my goods. I used reasonable care when I was imported, classifying my goods this way because of XYZ. I give them that explanation whether they like it or not, because I don't want them to go down a penalty rabbit hole. And I'm trying to stop them because I know when they're starting with the 28, that it's not just the stop of it. My goal is to get them to stop at the 28. But if you just give customs what they want, you're feeding into their plan to attack you. So it's like if the government is coming to you, in this instance, they are not, hi, I'm the government, I'm here to help. There is nothing helpful about this. Separately, if you're ever filing a protest, and unfortunately, we just had a situation where a client came to us where they entrusted a broker to file a protest on their behalf for a lot of money at issue, and the broker didn't file it correctly. The broker didn't request further review. It's called AFR, further review. So the same person that issues this request for information issues a notice of action and then reviews your protest. If this person didn't like you at the beginning, the chances of them liking you now and agreeing with what you're saying are few and far between. But when you request further review, you're asking somebody in a different department in headquarters to review what this person who you know doesn't like you is thinking. It is crazy to not request further review, because if you don't do that, you're diminishing your administrative rights, and then you're forcing your client to go to court to fight about it, which could be $100,000+ to fight about it. So AFR has saved our clients' lives a multitude of times, and we often see when consultants that don't file protests or don't know the regulations as well, and they're utilizing the protest mechanism, but not doing it to their clients' full service. So I beg of you to think of this a little differently. When 28s, 29s, protests, any of these horrible words come about, it's a really good time to think about getting counsel involved. All right, here's an example. If Customs is sending you a request for information to verify that you're using the U.S.-Colombia Free Trade Agreement correctly, what should you do? Should you ignore the notice? A. Should you respond thoroughly and timely? B. Should you communicate with an expert to discuss what documentation you may need? Or B and C, should you respond thoroughly and timely and communicate with an expert? All right. Quite often, when we see Customs issue the request for information, it's often Customs knows we made a mistake. And once we look at it, we talk to our client, we see, yeah, you did screw up. This wasn't pretty. but we don't respond to just the 28. Quite often, we also respond with a prior disclosure. This means that you're not formally under investigation. And then the prior disclosure gives you the benefit of taking penalties off the table. So it's a wonderful program, but it's very easy to screw up. You have to submit your prior disclosure properly and timely. And if you do, penalties are off the table, and all you would pay, for example, is interest. You still have to make customs whole. So let's use an example. Cesar was an importer. He used the wrong classification, and he underpaid customs duties to the tune of $100,000. What we do, we file the prior disclosure, and Cesar has to put $100,000 back on the table, plus interest. And then when he does that with the prior disclosure, customs would close it out, and your penalty would be the interest that you paid, and that's it. And then customs would wish you happy importing. If you didn't file that prior disclosure, you'd have to pay the $100,000 if customs is on to you, and then you could get a penalty for $200,000 on top of the $100,000. It's something we are consistently saving our clients from, and an analysis we're often doing right when our clients are importing and getting these requests for information. All right, this is the last few slides, Cesar, don't worry. And we've been getting some questions as we go, and if anybody else has any, I'm happy to take them as we're going. So the last one here is, if you ever get any notices from the government, be proactive. I always say, never, ever, ever pay without a fight. So if you get a detention notice, seizure notice, penalty notice, we get penalties mitigated consistently. 50 grand down to $100, 4 million down to 4,000. Those are real life examples of what we've had. So we've got a few tips for you. This is the top 10 tips that summarizes everything we talked about in one page. This is just for food related companies, for example, where you download this and it just talks about food importations. It talks about FSMA, your FSVPs, your reasonable care requirements, and it gives you a good one-page cheat sheet. We do the same with anti-dumping and countervailing duties. This is the #1 issue that we are currently seeing enforcement-wise with U.S. Customs, because the duties can be as high as 1,700%. Imagine not anticipating 1,700% duties. That is insane. There's nobody that can survive that. You didn't include that in your margin and it's too late. There are a lot of websites to check and a lot of homework to do. And quite often, importers have no clue. I like the search. You're also responsible to know that there are 700 orders for anti-dumping different cases that are going on from all sorts of countries. Like there's anti-dumping on pasta from Italy. Who would have thunk it? There's lots of anti-dumping matters for all sorts of items. Wooden bedroom furniture, receipt paper. We deal with all sorts. It's a huge issue that you don't want to forget about. We've got a lot of useful links for you, and this is the last week where we're doing a 50% off all of our webinars. This was our Labor Day sale. For another couple of days, we have a lot of webinar topics in our database, and we do a weekly blog, a monthly newsletter to stay in touch with us. There are lots of different ways to stay in the loop, because one of the hardest things that I notice is that you wind up having 47 agencies to keep in touch with, and you're supposed to keep in touch with everything going on in your world. How? How are you supposed to do that yourself? Are you looking at Federal Register notices every day? Are you reviewing all of the federal government websites every day? We are. That's what we do. So we summarize those for you in our newsletter and our weekly blogs. We also have the cutest head of security. This is Lucky. He is awesome. He's our rescue. He has his own little Insta page, and we've got lots of ways to keep in touch in our link tree. I put my LinkedIn in the chat box as well. So I know Lucky's so cute, right? My little heart and soul. So lots of ways to keep in touch with us, and happy to answer questions that you guys have and or be a resource when you're importing or exporting in the future, because having a great customs broker like Juan is absolutely step one. But when things go wrong, and people are people and make mistakes, you need a rock star customs attorney as well. And that's the resource we hope to be able to provide. So thanks for having us, Cesar. It was really a pleasure to talk to everybody today. And I'm happy to go through some more questions anybody has.
Thank you very much, Jen. If someone has a question, feel free to jump in. I have one, Jen.
Yeah.
Before I make any mistake, so are many of these legal requirements considered what's called non-tariff measures?
They're all non-tariff. They're what we call non-tariff barriers for trade.
Barriers.
So the
yeah.
idea is it's a non-tariff barrier. Like you can have a free trade agreement with Mexico, but that doesn't mean it's easy to import into the United States.
That was going to be my actual question. Is like, have you seen more of those as we're getting more free trade agreements? Are those non-tariff barriers increasing at the same time?
Yeah, I mean, it doesn't go away because now you also have gender norms and you've got forced labor issues and you've got environmental issues and you've got all the other things that are coming to the table as well. You still have to pay duties. You still have to confirm that you're utilizing the free trade agreement correctly. For example, I'm dealing with AGOA right now, the African agreement. And the question is whether the processing that occurred in Africa was good enough. So it's not just good enough that they actually did perform processing in Africa were good enough to take advantage. Now it's let's analyze the processing. Was it enough processing? Because if it wasn't enough processing, then you don't get to use AGOA. Okay, so now we're nitpicking the amount of processing to figure out whether we should or shouldn't use AGOA. And so it's, to me, this is, it sucks in some instances because it's just so difficult. Like what normal person knows the words double substantial transformation? Like we're not speaking English. We're not making it easy for manufacturers and importers to take advantage of these free trade agreements without compliance departments. It's, to me, these are the numerous ways that we screw the little guy into making great decisions, because if they don't spend money on compliance and have the right teams in place, it's virtually impossible to get this right.
Perfect. Thank you. The other one, and probably Juan can cover on this. Is there anything you mentioned about the Spanish labeling before? Is there anything that importers from Puerto Rico really need to pay attention to, because it's different? Spanish was one of the things you mentioned, but it comes to mind, and probably Juan and Pushi can add about the local.
I will give them a plug. You need a Puerto Rican customs broker to import into Puerto Rico. So you can't just use any old customs broker. You have to use a Juan. They have to be in Puerto Rico. It's not just any customs broker that knows Puerto Rico requirements. Puerto Rico's a separate beast, and you need a Puerto Rican broker. So Juan, Pucci, any other comments on that in regards to why you rock and why everybody needs you versus anyone else? Because you do.
Yeah, actually, I would like to add, Pucci explain, because she works on coffee importation, and I know there's some a local government requirement for coffee. I believe you have to pay the taxes directly to them and not to customs. So Pucci, can you explain more detail regarding that?
Yes. In the case of coffee, coffee imports into Puerto Rico, if they are imports made by the Puerto Rican government for their production, they don't pay any duties, not to customs and no taxes to the local government. But in the case of a private importer, like for example, I do have a big food distributor in Puerto Rico that brings coffee products from Colombia. These do pay taxes to the local government, not to customs, because it's coming from Colombia, which has a trade agreement. So even though customs does not collect taxes from that import, they do collect the money to pay our local government. They handle that collection. So probably if you import, if you use a US customs broker in the US, they don't know this fact. So that's why in this case, we would be your choice for a broker.
Does that happen with any other product?
I'm sorry?
Does that happen with any other type of product besides coffee?
Not that I know right now, but for the coffee, that's the way it works. We are handling something that we have another client who brings coffee from Italy, and he's smart enough that now he imports his shipments not to San Juan, but to Florida, because he doesn't have to pay that tax if he imports in Florida. Now he's trying to set a business, a virtual shop, to sell his coffee products. And he has a very good relation with the local agriculture department. And he was consulting with them. How can I pay this tax to you from the sales that I make online to Puerto Rico? And funny enough, the director said, we don't know how to manage that. So if you sell to Puerto Rico, that's taxes we won't see. So imagine that.
Okay. No, that's very interesting. I know. Juan, do you want to add something? Juan or Dana?
All of that, when you're importing any product into Puerto Rico, so besides the custom release, you have to fill a form with the local government and get the release from the local government in order to take out the product from the port. If you don't do both, you will not have your product. So that's something that.
What Juan just mentioned is in the link that Jen just posted on the chat.
Yeah, I see that too. I'm just so overwhelmed by the fullness of the information that each of you have provided. Part of my heart is in Puerto Rico. One, because I host a conference there. Two, because I just love the island, and I'm always looking for ways to do more business there, bring more clients there. And this importing piece is really important. But I know that during the time of Hurricane Maria, when people were trying to get items into Puerto Rico, something called the Jones Law prohibited countries from donating if they didn't go through the United States or have it on a U.S. ship. Why are they penalizing people that want to do more for the island? And how can we get that law changed? Like, what's going on behind
You need
the
lobbyists for that. That's beyond my pay grade. It's silly. I mean, it would, a lot of anti-dumping is rooted in protectionism, and you wind up screwing U.S. importers as well. So you have U.S. entities in the mix that get screwed just the same. So it all started because U.S. ships said, we need this. And so it's the question is, whose voice is the loudest? And if you're not in D.C. and you're not lobbying, your voice isn't heard.
It's not happening. Absolutely. Excellent. Thank you, Jen. Thank you, Pucci. Thank you, Juan.
And then since we have you there, and I don't know if Juan or Jen has plans to write a book, but then I just have a minute and let us know about your conference and invite everyone here in the room.
Thank you so much, Cesar. I'm excited for Global Chamber Puerto Rico, just making things happen. So every year we host the Transformational Writers Conference in Puerto Rico at El Conquistador Resort. And this year's it's happening again, December 7th through the 10th. And we will be hosting that. And the day prior to that, there will be a Global Chamber Puerto Rico meetup. So we'd like to invite you all to join us. I have the link here on my page, and I'll post it again. So if you have questions, you'd like to be a part, come meet our industry experts. Of course, we're going to have local publishers and writers, and then folks that are coming in, as well as Cesar. He's been one of our annual speakers. So join us. Bienvenidos a todo a esta conferencia de escritores. Thank you, Cesar.
Perfect. So I think I'm going to be wrapping up now. I'm going to be sharing a master follow-up with the recording of the call, and then following that email, Jen's going to be sharing all the materials and the QR codes and all that she shares. So thank you, Jennifer. Muchas gracias, Juan. Gracias, Pucci. Estén pendientes a todo lo que les voy a estar compartiendo y a las siguientes llamadas que tendremos en los próximos meses.
Sí.
Thank you, everyone. Have a great day. Thanks, Cesar.
Thank you.
Bye, everyone.
Thank
you so
you.
much.
Bye-bye.
Bye-bye.
Thank
you.